47 now, ma'am. He is unable to work also. He is now going for Coolie work, ma'am. Yes, she is working and drawing a salary of 50,000 rupees. This is a restitution of conjugal right, my lord. I am ready to take back her. So question of maintenance does not arise. In the High Court has not recorded any evidence. Only on the basis of the objection, trespass in the order. Actually, and some reasonable reduction has to be made. That's only.
What is the reasonable reduction? 1,000?
No, not 1,000. At least 4,000 or 5,000.
Yes.
This is husband's reputation. The trial court has granted a maintenance of 7,000 rupees per month, my lord. 7,000 rupees per month.
To the wife. You appear for?
I am for the husband. The husband is was a security man.
24.
Please.
Have they not executed the order?
No, they are not executed.
What happened to these arising out of criminal miscellaneous or
Civil miscellaneous? Section 24. I have filed a restitution of conjugal rights under Section 9 of the Hindu Marriage Act. Now,
these are an application that's arising out of an MC?
MC, please.
In the MC, you filed an IA.
The wife has filed an IA.
That's what.
Please.
So the MC is still pending.
Still pending.
Now it has to be ordered. Notice has to be ordered in the 2020, in the year 2020.
Notice served. They have unrepresented.
Please argue.
Please.
Please come to
served
the
and unrepresented.
Please come to the order.
Please.
Where is the order?
At the next chart, at in page 54, ma'am.
Yes. Please read.
Reasons, my lord. Point number 1. The present application is 24 of the Hindu Marriage Act by the applicant respondent against her husband, who is the opponent petitioner seeking interim maintenance pending litigation initiated by said husband seeking dissolution of the marriage on the ground of cruelty. In this case, the fact that parties to the proceedings are legally wedded couple having solemnized marriage on 9/6/2004 is not in dispute, and is also not in dispute that the couple has a 16 years old child out of their wedlock. As such, the right of maintenance for the applicant respondent is inherent in the inception of the said marriage itself. However, having regard to the purview of present application, Section 24 of the Hindu Marriage Act is concerned. The test is whether wife has an independent income sufficient to maintain support, and that she is in requirement of financial assistance to meet the expenses of the proceeding. In this connection, the respondent accepted pleading that the petitioner is a security guard with a salary of 25,000 along with an agricultural income, rupees 5 lakhs per.
The age of the petitioner?
47 now, ma'am. He is unable to work also. He is now going for Coolie work, my lord. Yes, he has a dismissal from security man when he was in during a COVID period, my lord. Whereas she is working and drawing a salary of 15,000 rupees. And I have got my mother. I have to look after my mother also, ma'am.
You have to look after your son also.
Her son, yes, he's a major now, of course. Now he's a major. And from 2000,
from when he has become a major?
Major now just 1 year. 1 year.
1 year back. So anyhow, till such time you have to pay.
My submission is that, my lord. I even have no work, but however some Coolie work I have done here and
Till
there.
now you have not paid any amount to them.
So far, not. It is a permanent element granted by trial court, Section 24, not interim maintenance. This is a restitution of conjugal right, my lord. I am ready to take back her. So question of maintenance does not arise. In spite of that, she filed Section 24 first time. So far, they have not. She has not filed any interim application before any court.
This is an IA filed under the
IA filed
in MC.
Yes. No, the 7th, actually 24th, she has filed an IA.
Yes.
My submission is that in so far as 24 is concerned, capacity of the spouses has to be looked into, my lord. In this case, she is working. In fact, I have no fixed source of income. 7,000 is ordered.
What is the evidence before the court that she is earning?
I have filed my affidavit stating that she is earning, and I have.
Not affidavit. You can say, she also can say so many things.
But
what is the material before the court that she is earning?
My main matter is for restitution of conjugal right, my lord. Now the interim application only
asking restitution of conjugal rights, but she has her own difficulties. Why she is not able to come back? She has her own reasons for that. No, as far as maintenance is concerned, according to you, she is working.
Please.
That's what you are saying.
Please.
What is the evidence placed before the court in that regard, except your assertion in the affidavit?
Please. That is the only, because it is
You have
again
You've not
interlocutory
adduced
stage,
anything.
madam.
You have
It is-
not adduced any other evidence.
The trial court has not recorded any evidence. Only on the basis of the objection, it has passed the order. Actually, inquiry has to be conducted. In view of the dispute between the parties, whether I have got capacity to maintain her, or whether more income she is drawing. At least minimum inquiry is necessary. No, only on the basis of the objection.
You have forgot about the wife.
Please.
You have a son. You have to maintain him.
Please.
No, it is for both son and wife or
Only for a wife and including son and Chalida. She has filed, including son, but she only filed application.
no. That's what on behalf of son also.
On
This is
behalf
the
of son, no.
application filed by so and so maintenance, including herself and a minor son.
A minor son.
Uh.
Now he's a major, man.
Till
Please.
from the date of order till he has become major, you have to pay.
Please, that is true. But so far as 7,000 is concerned, my lord,
So how much you will pay?
thing is very difficult, and I am getting Coolie work, my lord. Some reasonable reduction has to be made. That's only.
What is the reasonable reduction? 1,000?
No, not 1,000. At least 4,000 or 5,000.
5,000 will make.
Please.
Please come. Agreed with the orders passed in I number 1 in MC number 9 of 2020, dated 21/4/2021. The husband is before this court. The respondent herein, MC is filed by you.
And please pardon.
MC number 9 of 2020 is filed by the petitioner herein, seeking restitution of conjugal rights. In that, wife had filed I number 1 under section 24 of the Hindu Marriage Act, seeking interim maintenance of an amount of rupees 30,000 for herself and her minor son. It is her case that the petitioner is working as a security guard and earning an amount of rupees 25,000 per month. And because of the harassment by the petitioner, she had to leave the matrimonial home. And he's also having agriculture income and is having more than 5 lakh per annum. And works as a manager in a picture talkies and earns rupees 30,000 per month. And despite having the income, he's not maintaining the wife. The husband has filed his objection stating that the wife is earning, is doing coolie work. He is not in a position to work because of the health conditions. He has to take care of his mother who is having ailments. The trial court had granted maintenance of an amount of rupees 7,000. While granting the maintenance, the court has observed that in an application like this, the court has to find out whether the respondent has sufficient source of income to maintain herself, whereas no such material is forthcoming before the court to say that the wife is capable of maintaining herself and the child. And the court observes that it's a bounden duty of the husband to maintain his wife and children. Though the wife had not proved exactly what is the income of the husband, it would be just and proper to grant reasonable interim maintenance along with litigation expenses in order to facilitate the wife and a minor son to lead a dignified life. Accordingly, an amount of rupees 7,000 What is this 7,000?
7,000 to the respondent, including her son from the date of petition.
Hence, it would be just and proper to order in lump sum. Expenditure is in total 7,000.
Litigation expenses.
Expenses is 7,000 and 6,000 is interim maintenance.
Hello. Litigation expenses 6,000. The petitioner also liable to pay litigation expenses total 6,000.
Read it, page number 61, bottom. Bottom 4 lines.
Please.
Hence. 61.
61. Fine.
Yes.
Yes. lump sum the pendente like
No,
expenditure.
hence it would be just and proper to order.
It would be just and proper to lump sum the pendente light expenditure in total 7,000 and 6,000 per month as interim maintenance to the.
So
respondent.
what the court said is 7,000 is litigation expenses, 6,000 is maintenance.
Yes. Actually, 7,000 maintenance, 6,000 litigation expenditure. At the operative portion, it is there.
The court had granted 7,000 as maintenance and 6,000 as litigation expenses. Next para. The notice is served on the respondent. No wakalat is filed on her behalf. Land counsel, next para. Land counsel appearing for the petitioner, husband submits that the petitioner is doing coolie work. Now the son has also attained a majority. The wife is working. All these aspects were not considered. When the husband has taken a plea that the wife is earning, the court should have conducted the necessary inquiry in that regard. And without any basis, the court had granted the amount. It is submitted that he has to take care of his mother and has to take care of his health. And also both of them are having health ailments. And it's very difficult for him to pay maintenance of an amount of rupees 7,000. Next para. This court, having heard the land counsel for the appellant petitioner, this court has perused the order passed by the trial court, except stating that, the wife had stated several things like he's having working as a security guard, working in attackings, and also is having agriculture income, but there is no evidence in that regard. The court had granted 7,000 as maintenance and 6,000 as litigation expenses. Considering the fact that he's working as a coolie, the coolie this court deems it appropriate to reduce the maintenance from rupees 7,000 to 5,000. The petitioner shall pay the amount of arrears at rupees 5,000 from the date of petition. From the date of petition till today, within a period of
4 weeks.
4 weeks.
Much.
Accordingly, the petition is. Yes.